All right, we'll take 25 FY1078, the State of Michigan versus Roconda Singleton. If we could have appearances for the record.
Travis Early on behalf of the people.
Or Joyce, on behalf of Ms. Singleton.
Alec Hay appearing on behalf of Ms. Singleton.
All right, good afternoon, everyone.
Good afternoon.
We had set this for a preliminary examination. Are the people ready to proceed?
We are, Your Honor.
Are there any issues we need to discuss before we start taking testimony?
From our perspective, Your Honor, there is one thing now. The people, I believe the defense and I have stipulated to the admission of Dr. Start's autopsy report. I've marked it as proposed Exhibit 5. I did have him subpoenaed for this afternoon. He indicated he was running behind. Ms. Joyce indicated that I believe that she would not object if I proposed this report for the court's review.
All right, Ms. Joyce?
That's accurate, Your Honor.
All right, now we'll note that entry of proposed Exhibit 5, or Exhibit 5 is received and is entered by stipulation of the parties.
Other than that, Your Honor, Ms. Joyce asked that I sequester witnesses, and I've done that.
Okay. All right, then if you're ready to proceed, if there's nothing else.
That was all, Your Honor.
All right, very good. Thank you.
Thank you. The people call Officer John Vandenberg.
Mr. Vandenberg, please right hand. Do you swear the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. If you would, state and spell your full name for the record.
John Michael Vandenberg, JOHNVANDENBERG.
All right, you may examine the witness.
Thank you. Sir, could you please tell the court where you are employed?
I am a Grand Rapids police officer.
And how long have you been a police officer there?
A little longer than 6 years.
Okay. And were you working as a police officer on January 25th of this year, 2025?
Yes.
At some point, and just for the record, you're obviously in street clothes this afternoon. Back in January 25th of this year, if you would have been involved in a report, would you have been in a uniform at that point?
Yes.
Okay. Are you still a uniformed officer, or has your responsibilities changed?
I'm currently on light duty due to an injury, but my official assignment would be road patrol when I'm healthy again.
All right, thank you. So when the public sees you out and about, you would be in uniform then?
Correct.
And on approximately 7:25 a.m. on January 25th of this year, were you dispatched to a house fire?
Yes.
What kind of information other than a house fire did you have prior to, I guess, did you go to that house first of all?
I did.
Prior to arriving at the house, what other information did you have, if anything?
I believe the original dispatch was from a caller who was uninvolved or came by and saw it and was trying to get people to evacuate the house.
Okay. Fair to say you didn't really know what was in store for you when you arrived at that home?
That's fair to say.
Okay. And could you tell the court where, which house you were dispatched to, the address, if you recall?
I believe it is 956 Eastern Avenue Southeast.
And is that here in Grand Rapids, Kent County, Michigan?
That is in the city of Grand Rapids.
What, if anything, did you observe when you first arrived at that home?
The main floor of the house was fully engulfed in flames. Flames were coming out of the doors and the windows, kind of lipping over the roof of the front porch, and the second floor windows were just black with smoke.
Were you able to tell, if you were even paying attention at that point, whether there were any people out and about or in the front yard of that residence? Or
There were people outside. I first spoke with a small group of people off to the northwest corner of the lot on the sidewalk, and then there was one other person they identified as Ms. Singleton off to the southwest corner of the lot on the sidewalk.
Okay, so a handful of people or more that were actually outside at that time?
Correct.
Was it daylight at that time of the morning?
This was before dawn. It was dark out still.
Okay. And did you make contact with the person that was later identified as Roconda Singleton?
I did.
Where, if you recall, where exactly did you make contact with her at?
It was on the sidewalk off to the corner of the lot, almost to that next intersection. I'm not sure what that cross street is, but it's a corner lot. 956 is a corner lot, and there was where the sidewalks intersect, I guess.
Were you a safe distance from the home at that time?
Yes.
When you made contact with Ms. Singleton at that point, was the house still engulfed? Were there still flames coming out?
Very much so.
How is it that you identified her? Do you recall?
She provided her name and date of birth.
All right. Did she come up and introduce herself, or did you ask her who she was?
I had to approach her and start the conversation.
All right. And the person that you identified as Wakanda Singleton, do you see her in the courtroom today?
I do.
Could you identify her by something she's wearing?
A navy blue top and pants.
Your Honor, may the record reflect that he's identified the defendant?
Without objection, so reflect.
Not objection.
So reflect.
Thank you. And other than asking for and obtaining her name, did you ask whether she had anything to do with that home or if she was connected to that home in some way?
I asked who was still in the home. Speaking with the group of people on the other corner of the house, they had indicated that she had been in the home or was the mother of the children who I would later speak to. And I asked who was still in the home. She said that her daughters were in there and that one daughter was still in there.
Okay. Were there any other police officers on scene at this point?
They were arriving behind me. I assume some had probably arrived at that point.
Okay.
I was the first there, but there were several close behind.
What about the fire department, if you know? Did you arrive before or after them?
There was one fire engine that was the vehicle directly in front of me as I arrived, and the next vehicle behind me was a second fire engine.
Do you know whether or not those firefighters were speaking to that same group of people? Like, did you observe them doing that?
I was the first person who spoke to the small group, and then for several minutes, for a good amount of time, I was the only one who spoke with Ms. Singleton.
Okay. Did you relay information to the fire department that there may still be someone inside the home?
I did.
Okay. And do you recall which firefighter, anybody that you would have talked to, or is that just something that?
I don't know who it was.
Sure.
It was the closest firefighter to me.
Okay. All right. So in person, physically to a firefighter on scene.
Yes.
Did you learn through the defendant that there were any children that were already outside of the home?
Yes.
Okay. And did you learn where that child or those children were at that point?
I had learned where those children were from the first group of people that they had been put into the neighbor's house to stay warm, I suppose. And Miss Singleton knew that the two got out, but I don't think she specifically told me where they were.
Okay. So you were kind of learning things piecemeal, depending on who you talked to.
Correct.
All right. And those other folks that you indicated you spoke to, did they appear to be neighbors then, or passersby?
Yeah, one or the other.
Okay. Not actually folks that lived in the home.
Correct.
Did you eventually identify the exact home that any of her children were taken to or arrived at?
Yes.
Do you recall what address they were at?
950 Eastern Avenue, so the first house to the north.
Okay. And did you make contact with the homeowner or person that lived in that home as well?
I did.
When you made contact with with that person or those people, did you actually learn that there were other children related to the house fire inside of that home, the 950?
Yes, there were two children.
Do you recall their names at this point?
Cherish and Charlotte.
And were you able to find out how old those children were?
I believe they were 10 and 7.
Okay. And did they appear, for lack of a better word, did they appear unharmed, at least as it relates to the fire?
Generally so. Cherish was complaining of rib pain.
Okay.
And then eventually both of them were assessed for smoke inhalation by
Sure.
AMR.
And eventually, it's my understanding, they were treated at the hospital as well.
That's correct.
At some point, before making contact with Cherish and Charnice, did you talk to the defendant about the fact that she was outside talking to you and her children were inside at 950?
I asked somewhat of a vague question of what happened.
Okay.
I did not specifically ask why she was where she was and why the children were where they were.
Okay. At any point at that time, did you have any concerns about uniting her with the two children that were in 950?
I did ask if she wanted to go be with her two children, yes.
Okay, and what was the response, if any?
She did not have a strong response at first and ultimately said that she wanted them brought to their older sister's house, which was a mile and a half away or something like that.
Okay, that the defendant wanted her, the children taken to her sister's home?
Their sister's home.
Their sisters, okay. I'm going to show you what's been marked as proposed exhibits 1, 2, and 3. Should pull this already. Could you just thumb through those three and let me know if you recognize what's in the photographs?
Yes. That is 956 East.
Is that eventually the way that the home looked after the fire department was done doing their duties?
Yes.
Your Honor, I ask for the admission of exhibits 1, 2, and 3.
Any objection to the admission of exhibits?
No
1, 2,
objection, Your Honor.
All right, and they will be admitted.
Keep those to the court then. Were you still in a, I guess, in a position either before or after speaking with Cherish to see the fire department working on 956? Do you know what I mean?
Could you repeat the question?
Sure. At some point, did you see the fire department looking for any other people inside of 956 Eastern?
Yes.
Okay. And was that going on while you were speaking with the defendant and the children, or was that separate times?
It was while I was speaking with Ms. Singleton.
Okay. And where in relation, I'm sorry if you already said it, but where in relation is 950 to 956?
It is the first house to the north.
Okay, so next door?
Yes.
At some point, did you see the fire department appear to be carrying out another person?
Yes.
And where was that from?
I was with Ms. Singleton to the southwest of the home by that intersection of sidewalk that I mentioned earlier. I think we had actually crossed the street to the south to get behind another fire engine to give the fire department room to work. But the fire department came in from the east side of the home through a second story window. I suppose they had a ladder against the side of the house. I'm not sure if it was a door or a window they went in, but from the east side of the home. And eventually they came out the west side of the home onto the front porch roof. And other fire department officers had placed another ladder on the south face of the porch. And they came off the roof and down the ladder.
Did you see all of that happening before you spoke with Cherish? The 10-year-old?
I had spoken very briefly with Cherish and Charnice to try and determine which children were there.
Okay.
And it was between that very brief conversation and the more extensive conversation with Cherish.
Were you able to tell whether the person that was carried out by the fire department seemed to be conscious or not?
They did not appear to be conscious.
Were they transported into an ambulance or somewhere else right away?
Immediately the fire department brought that person down onto the ground and began CPR, life-saving measures.
Okay, so
right then and there.
that occurred right there in the front of the home?
Yes.
By the time that you were, I guess, relieved of any duties at the home, I guess after speaking with the children that you spoke to and seeing the fire department do what they did, what were your duties for the remainder that you were on scene?
So I spoke with the children again. AMR came and began care for them. and they were eventually moved to the ambulance. The older sister of the children had arrived. I spoke with her briefly to let her know that the children would be transported to Helen Wells Children's Hospital. The fire department person, investigator, I believe, started speaking with the children. I observed part of that conversation, and then the children were transported to the hospital where I eventually met up with them.
Okay, you did actually follow them to the hospital?
I did go to the hospital, yes.
Okay. And do you recall the older sister's name that arrived on scene?
I do not.
Okay. I think that's all I have for you, officer. Thank you.
Good afternoon, officer. Just have a couple questions for you. I want to go back to you arriving on scene at 9:56. Now, when you arrived, you stated that the home was sort of engulfed in flames, correct?
Correct.
And at that time, you're going around and you're looking for people to talk to that are outside, correct?
Correct.
And you come across Miss Singleton, yes?
Yes.
I believe you state that she was at a corner, correct?
Yep.
About how far away from the house was that?
40 feet, 50 feet?
Okay. And again, at that time, it's obviously within Miss Singleton's view that this house is on fire.
Correct.
Yes. And at that point, she makes a statement to you stating that she does not know what happened. Is that correct?
That's correct.
So you stayed with Miss Singleton for quite a bit, correct, as this is going on?
Yes.
And you're still at the outside of the house as this house is engulfed in flames, correct?
Correct.
And while this is going on, Grand Rapids Fire Department does show up, yes?
Yes.
And you're with Miss Singleton at this point.
Yes.
And as this is happening, as the fire department goes into the home, they come out and bring what looks like a lifeless body coming out of the home, correct?
That's correct.
And that you come to find out that is Shemaya, yes?
Yes.
And as this is happening, this is in full view of Miss Singleton, yes?
Correct.
And you state that in your report that she begins exclaiming and ranting about something at this point, yes?
Yes.
And what she's ranting and exclaiming about is that her daughter, the one that is coming out of the house, Shemaya, has been raped multiple times, yes?
I believe that's correct, yes.
Yep. And you also, she also states in that ranting and raving kind of behavior that some man had done this.
Your Honor, I'm going to object to any further hearsay elicited by the defense at this time.
Your Honor, I would argue both that this is present sense impression as we're outside of the house. Number two, these statements are made as Shemaya is being brought out of the home. Again, I would argue that this is an excited utterance. The word ranting and exclaiming are used in his report. I can't think of a better definition of an excited utterance.
Your Honor, it's an utterance that has nothing to do with the circumstances happening. For instance, present sense impression doesn't apply because she wasn't witnessing any sort of rape. It may be excited, and it may be an utterance, but it's not relevant for the investigation that this officer was there for, or what was happening.
What are you offering it for? Where's this going? I mean,
Your Honor, I only mean to bring in what was said as Shemaya was brought out of the home, the statements that were made by Ms. Singleton as she is viewing this going on.
mm-hmm.
And I believe that to be an excited utterance, as is stated by Officer Vandenberg, that these were ranting and exclamations, and even used the statement, random statements. So I think that these are excited utterances.
Well, what do you say about the materiality, though? Isn't materiality an issue in that with the excited utterance?
Your Honor, if I may have 1 second.
Mm-hmm.
Your Honor, as I read MRE 8032, it excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress or of excitement caused by the event or condition. And I think that the event or condition is Shemaiah being brought out of the home.
People have a response to that?
Yes, Your Honor. It still needs to be relevant under MRE 401. So any excited utterances about her child having previously been sexually assaulted is not relevant to this officer's testimony.
Well, I think what we'll do, I'll allow it to the extent that the court might find it relevant, certainly as far as the truth of what's being asserted, but I don't think you're offering it for that purpose anyway. I don't know at this point, I guess.
Your Honor, I am simply bringing in the utterance that was made as Shemaiah was brought out of the home.
I'll overrule the objection.
Thank you. So just to go back, it's at this point, after she had made claims of someone had raped her daughter, that she also made statements to you that a man had done this, correct?
I believe that's correct, yes.
And it also states that you know exactly what's going on, referencing you, Officer Vandenberg, correct?
I'm not sure about that. Can you repeat the question?
During this event, as she's speaking to you about you know what's going on, it's your understanding that she was referencing you, correct? Do you not know?
I do not know.
Would it refresh your recollection if I brought you your report?
Yeah.
If I may approach.
You may.
And you can look up when you're finished reading that.
Oh. I remember that statement. It was out of the blue. So, shall I quote it or?
No, that's all right. But would it, again, so it was out of the blue, correct?
Yes.
As you stated, and random, as you put it in the police report, yes. And again, the statement was, that man did this, correct?
No.
What is the statement?
That man said I did this.
Okay. And then she goes on to say, you know exactly what's going on, correct?
Yes. So.
It's a yes or no question. I apologize, but
Ask again.
Miss Singleton makes the statement, you know exactly what's going on, referencing you know exactly what's going on about this situation, whatever that may be.
Yes, that is what she is saying.
I have no further questions. Thank you.
Counsel, anything further from the
Well, I guess I just want to clarify that statement that the defendant made to you then, officer. Was it that man did this or that man said I did this?
That man said I did this.
Okay, and your report has a question mark after this, as if it's a question.
Correct.
Were there any people standing around, males, that indicated that she had done whatever this may have been?
I was the only one nearby at that time.
And when she said to you, you know exactly what's going on, did you personally know exactly what's going on?
No.
Okay. Did you know what she was referencing by saying that you did?
I can speculate.
I don't want you to speculate. Did you know what she meant?
No. It would only be speculation.
All right. Nothing else then, Your Honor.
anything further?
I have no further questions.
You may step down. Thank you very much.
Your Honor, the people would call Lieutenant Harold Elmore.
Would you raise your right hand? You swear to testify testimony about to give away the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated, and if you would state and spell your full name for the record.
My name is Lieutenant Harold L. Moore. That's Harold. Last name Elmore.
You may examine the witness.
Thank you. Sir, could you please state where you are recently retired from and for how long you were there?
Grand Rapids Fire Department and served for 26 years.
Okay. And you retired just this year, is that correct?
Yes. February
All right.
2021.
And was that correct? You made it to the rank of lieutenant?
Yes.
All right. And for the record, again, you are in dress uniform this afternoon. At some point earlier this year, specifically January 25th of 2025, were you and other firemen or firefighters dispatched to 956 Eastern Southeast for a house fire?
Yes.
And at the time, do you recall how many different, there's probably going to be a terminology barrier between the two of us, but how many different, I guess, units from the fire department would have been dispatched to that?
We typically dispatch 19 individuals to a structure fire. But we have victims inside that can extend to about 25. So that's approximately 7 machines.
And on this particular morning, did you, did you know prior to arriving how many or if there were any people still inside that?
As we were going down the road, we were getting information updated on what was going on. Typically, we have a system where we try to see or visualize what the scene is like.
Sure.
Based on the information dispatch is giving us, and that lets us know how many machines are going to be called through. And this was different and unique at this particular time, so it was really hard to understand what was happening until we got there.
Okay. For firefighters, especially for those of us that may not know or we're not as used to dealing with firefighters as we are police officers, but do you get the 911 call yourself? Do you have a dispatcher? Or
Yes,
for instance, okay. And so are you getting information specifically from the dispatcher?
We're getting it both from our units on scene and dispatchers. So we're able to hear, we have our own channel for firefighters. And we're able to hear what's going on as units arriving on the scene. So we're getting on-scene arrival information and continued information by those individuals who are on scene along with dispatch.
So if there are units already on scene ahead of you, for instance, who are speaking with a Grand Rapids police officer who may be giving them or updating them information, is that the type of information you would expect to be relayed to you and other units that haven't arrived?
Absolutely.
All right, thank you. When you arrived at 956 Eastern, do you recall whether there were other fire units already on scene?
Yes.
And do you recall how many?
Those are 2 fire units on scene, I believe Engine 2 and I believe Rescue 1.
When you arrived on scene, had you learned, or had it been confirmed that anyone was still in this home?
Yes, we already had that information as we were, again, going to the scene. We got the update that someone was inside.
All right. And as a lieutenant in one of these units, are you kind of in charge of telling other firefighters what their responsibilities are?
I'm in charge of my crew and giving orders based on what we see and what we hear, and based on a formation that we typically have in the fire department. Typically, the first machine that comes on a structure fire, that machine is pretty much assigned to fighting the fire. The second machine typically comes in and set up water supply. The third machine would do rescue, etc. Because there were rescues announced on the scene, every machine that was there first was in charge of rescue.
Okay.
At one time. So
In other words, that rescue becomes
That's correct.
Priority.
that's correct.
And do you recall which unit would have been in charge of the rescue?
Engine 2 arrived on scene first, and they initiated fire attack along with rescue at that point in time because they couldn't get through the front door because of the amount of fire that was there. So they had to knock down some fire to try to go through. And other units also through ladders. I believe it was Rescue 1, through ladders to the AD side, which is the front and the south side of the structure, to go in and start rescue on the second floor above the fire.
Okay. What unit were you in?
I'm Engine 11.
Engine 11?
Yes.
And what were you and your crew responsible for?
We came up, we were third up, so we were assigned for water supply.
Okay.
Once we got the water sites established, that typically takes about 30 seconds.
Okay.
We were then assigned to do what we call RIC, which is where we set outside to look out after the other firefighters that are inside just in case someone goes down, then we go in and rescue them. While we were in that transition, Rescue 1 was bringing the child out of the AD corner second floor window. So we got redirected from Rick to then, at that point in time, medical care of the patient.
So your responsibilities fluctuate as the scene unfolds?
As it unfolds,
Oh,
that's correct.
Did you personally see members of the fire department rescuing or trying to
Yes.
rescue this child?
Yes, we were there.
And how is it, and again, if you don't mind using layman's terms, how is it that they were able to get that person out of
They
the
threw a ladder to the second floor, again, AD side, which is the front of the house.
So I was gonna
on the
ask you
south
that.
side.
Okay.
So that's a corner. That's a corner right there.
Yes, sir.
So they threw a ladder up to the second floor, and they went in and did search and rescue, and they found the victim in that room right there on that second floor, south side of the structure. They brought the victim out at that point in time. We were watching them as they were coming down the ladder with the young lady, and we were ready to take the hand off from that point on.
All right, thank you. That's what I was going to ask. Did you do so? Did you actually
Absolutely.
take over?
We were assigned immediately from the chief, who knew that the child was coming out, to get the med bags and everything ready, and we were reassigned again to take care of patient care.
Are there things, based on your experience, that you can recognize or that are obvious to you as far as injuries are concerned?
Absolutely.
Burns
Absolutely.
specifically?
Absolutely.
Were you able to tell whether or not this child had suffered any burns?
Absolutely. When we got her down, immediately you can see that her, what we call nasal on up, was compromised, severely burned with third-degree burns. Just to put that in perspective, we have 4 levels of burns minus frostbite. Okay, so we agree with first-degree burns, which is typical of owie.
Okay.
Second-degree burns is like a sunburn, blistering. Third-degree burns is when it starts to penetrate skin, bone, marrow, etc. She had third-degree burns from her nasal on up, which means now we have a problem with ventilating the person because now the breathing is compromised.
Okay.
So now we have to go strictly through the mouth, and we have to make sure and hopefully that whatever burned here did not go down inside of the whole breathing system.
Okay, all right. And are there measures that you as a fireman take to try to, I guess, to try to relieve whatever it is she's going through?
We do what we can on the scene, seeing those particular severe injuries happening right there. Again, we had to go strictly straight through the mouth and try to get ventilation while we're doing chest compressions. So let me back up first of all.
Sure.
When we get a patient, the first important thing is to find out if the patient is viable, meaning if they are alive.
Yeah.
Okay. Once the child came down, she had no pulse at all. No pulse. So once we check for pulse, first thing we do is we try to adjust the airway. That means open the head up so we can get some air in. Seeing that she was compromised here, we already knew there was going to be an airway situation here. So once we adjust the airway, we started doing air ventilations with BVMs and chest compressions. Chest compressions is the first thing we want to do, is because we want to start getting the blood, start circulating through the body, and get the chest, the heart working again. Okay. Once we start doing that, then we work on the ventilation. This particular victim was so severe that when the ambulance who came on scene, they immediately do what we call load and go. That means that a person is in such critical condition, we don't have much time to sit there and do the things that we need to do. We grab them, put them in the ambulance, and we do all those things inside the ambulance while we're heading to the hospital. So that's what we did there.
All right. And so if I'm following you, once an ambulance arrived, you personally went into the ambulance,
We stayed with the
yourself
patient.
and rode with her to the hospital?
Yes, my firefighter and myself, we rode and continued patient care at that time.
Your Honor, I'd like to approach the witness with People's Proposed Exhibit 4. It is a picture of the now deceased victim. I know the media is here and has been taking photos. It looked like they were recording some of the other exhibits. Is there any way I can ask, given that the family, I was purposely not going to produce it to the entire courtroom. Is there any way we can ask members of the media not to put this on the news?
Yeah, I would ask them to honor that.
Thank you. I'm going to show you what's been marked as People's Proposed Exhibit 4. Do you recognize who was in that photograph? Does she look similar to the manner that she was in that morning when you were attempting life-saving measures?
Yes.
And did she appear in that condition all the way to the hospital?
All the way to the hospital.
Would that have been the last time you saw her?
Yes.
Did you turn over medical personnel?
Yes, we
at the
did.
hospital?
Actually, we we were doing life-saving measures inside the ambulance, and actually when we were pulling up to the hospital, we got what we call ROSC, which is return of spontaneous circulation, meaning she has a pulse.
Okay.
So she actually had a strong pulse and a blood pressure, and in my line of work, that's what you look for and that's what you hope for.
Sure.
So when we got her there, she had those returned over to the hospital, and we feel pretty good about ourselves.
Yeah.
We did some good.
Your Honor, I'd ask for the admission of Exhibit 4.
Any objection?
No objection, Your Honor.
Okay, and Exhibit 4 will be admitted.
Give to the court, thank you. Thank you, Lieutenant. I don't have anything else.
Thank you, Your Honor. Good afternoon. So you did not actually get Shemaya out of the house, but you kind of monitored that process. Is that fair to say? Okay. But then once she was out of the house, were you part of the team that did do some life-saving measures on her?
All of them.
Okay. Can you talk about, I know you did talk about how you would be careful with her airway, correct?
Yes.
And you said, I think you mentioned chest compressions, is that correct? When chest compressions are done like that in an emergency scenario, can those cause injuries sometimes?
Yes.
So that's my question is if when you do those in the field, then do you report that to either the hospital or the medical examiner so they know that if they're recording these injuries that they could have been caused by the life-saving measures?
No. When you start talking about injury to the chest compressions, that's one of those things where, unless you're an elderly person, that's when you can hear the bones actually crack on the chest and whatnot. And you can hear it. But for a normal person, a healthy, like a 12-year-old person, the chances of you getting something to indicate that you did something, you won't get those things.
So the answer is no, you did not tell any doctors or the medical examiner about that?
There's nothing that was wrong with that patient. There was nothing that gave indication there was any injuries, none whatsoever.
Okay. And you rode in the ambulance all the way to the hospital, is that true? And then it looks like in your report, and I think you mentioned that at some point then a pulse was returned, correct?
It's called ROSC, yes.
Okay. And I know we talked briefly before court began, and I just want to make sure I clarify with you on the record that you do generate reports as part of your job. Is that right? And then this 2-page report, actually, can I approach the witness here?
You may.
I just want to confirm that this 2-page report is what you generated.
Yes.
And that's the total of what you generated as far as what was done in this case, or as far as what you did. Is that true?
1 second.
Okay.
That's affirmative.
Okay. So you did not generate any other report as a result of this incident. Is that true?
That is correct.
All right. And then, forgive me, obviously we all know police officers now are outfitted with body cams. Do you similarly have body cams or no? Okay. Are there any recording devices in like the fire trucks or anything like that? Anything further, Your Honor?
All right. Anything, any follow-up?
Just a brief follow-up. I know that it was evident to you that you were working on a child.
Absolutely.
Okay. Do you or your team do anything to identify that child or the age or anything like that?
When they're infants, yeah, you have to do measurements, certain things. But this child is a preteen right here, so everything is, in terms of the anatomy, is the same as your line. So there's no difference in preparation with that.
In that report Ms. Joyce is referencing, we have this young lady's name and age. Is that something that you would have generated or someone else from your team?
I would have generated that
Okay.
from the report, from information of the report.
Do you recall this young lady's name and how old she was?
No.
Okay. Would your report refresh your memory?
Sorry.
Would your report refresh your memory?
Yes.
May I approach?
Yeah.
As well?
Yes.
That refreshes your memory?
Absolutely.
What was her name?
Shamira.
And how old?
12.
Thank you. Nothing else, Your Honor.
Anything further?
No, Your Honor, thank you.
You may step down. Thank you very much.
People call Detective Brandon Romero.
right hand. You swear the testimony about to give you the truth, the whole truth, and nothing but the truth? You may be seated. And if you would state and spell your full name for the record.
My name is Brandon Michael Romero, Brandon, last name Romero.
All right, you may examine the witness, counsel.
Thank you. Sir, could you please tell the court where you are employed and how long you've been employed there?
I'm a police officer with the Grand Rapids Police Department, and I've been there since December of 2017.
And are you assigned to any particular unit of the police department?
I'm a detective with the major case team.
And major case, what does that all entail?
So we have four divisions of our detective unit. Major case handles violent felony crimes, infant deaths, any weapon-related offenses.
You've obviously been in the courtroom to hear me refer to a date of January 25th of 2025, is that right?
Yes.
Were you contacted by a supervisor to appear at 956 Eastern Southeast that morning, or did you arrive there by some other means?
I was contacted by my supervisor.
Okay. And was there any particular reason that you would have called you as opposed to any other detective at this point?
It was just prior to our start of our shift, so and that means it would be labeled as a call-out. So when he contacted me, I was the next person on the list, and usually we call out 2 detectives at that time, so that's why I was one of 2 detectives called.
All right. It was Amanda Johnson, the other detective?
That's correct.
On this particular morning, did you actually arrive at 956 Eastern?
I did.
Do you remember what time you would have gotten there?
I would say somewhere between 8 and 8:45 is my guess.
Okay. And I think Officer Vandenberg indicated that he arrived around 7:30 a.m.
That's correct.
Does that sound accurate as far as your review of the reports?
Yes.
Was the fire, had it been extinguished at that point?
Yes.
And were you introduced by other officers or your supervisor to kind of the people that he wanted you to be speaking with?
Yes, so I went directly to Sergeant Sachs, who was the South Service Area Sergeant at that time. And typically kind of how it works is you are briefed by the sergeant on what they have at this point. Sergeant Sachs just indicated to me that the call for service that they responded to and the fact that we had 3 children that were transported from the home to the local hospital.
All right. So the children had already been removed out of that area by the time you arrived?
That's correct.
At some point, did you make contact with a person by the name of Raconda Singleton?
I did.
And where physically did you make contact with her?
She was sitting in the back of a patrol car, I want to say across the street, fairly close to her residence, just where, I don't remember whose patrol car it was, but I was directed that she was in the back seat there, and that's where I made contact with her.
Okay. And do you know at that point why she was in the back of a patrol car, for instance?
I was told that she was the mother to the children, and that she was on scene upon arrival, and that there was some suspicious statements, I guess, or evidence that was provided prior to my arrival.
Okay.
So they had her in the back of the car.
All right. And you had not heard those suspicious statements prior to arriving, is that fair?
That is correct.
Okay. So upon arrival, it was kind of up to you to do any questioning that was going to happen, is that right?
That's right.
When you first made contact with with Ms. Singleton, how would you describe her demeanor? Do you recall?
She was quiet. She was sitting in the back seat. It's not like a priority of all detectives to do it, but I like to introduce myself, being that I was going to be one of the detectives in charge, so I introduced myself. Asked her if she needed anything at this time. She indicated that she did not. I did notice some burn marks on her person.
Okay. Some of her clothing as well, I think you might.
Yeah, her hooded sweatshirt appeared to have some heat charring, I guess you could say.
All right. Did you tell her that there was going to be further questioning somewhere else, or did someone else relay that?
I believe I told her that she was going to be transported downtown, and I would like to talk to her about what occurred that morning.
All right. And again, do you see the person that you made contact with that you identified as Ms. Singleton in the courtroom today?
I do.
Could you identify her by something she's wearing?
She's sitting to my right with a blue top, blue bottom.
Again, Your Honor, may the record reflect to identify the defendant.
Without objection, so reflect.
No objection, Your Honor.
Thank you. At any rate, did you or someone else transport her to headquarters?
She was transported by patrol.
All right. And was she brought downtown here to headquarters to be interviewed?
That is correct.
And was it you and Officer Johnson who conducted that interview?
Yes,
Was that interview recorded?
it was.
And prior to questioning, did you Mirandize Ms. Simmons?
Yes.
Did she agree to waive her right to speak to you?
Yes.
Again, was her demeanor any different at that point that you recall versus when you were back at 9:56 Eastern?
No, the best way to describe it was just quiet.
Okay. All right. Did she appear to be under the influence of any alcohol or drugs at that point?
No.
Did she seem to be exhibiting any, if you know, any symptoms of, I guess, anything out of the ordinary to you?
No, I would say what kind of like, the best way to describe it is quiet. I mean, I don't have another word that I.
Was she calm and quiet or something else and quiet?
She was calm and quiet. She wasn't like erratic or like stomping her feet or, talking out loud or anything like that.
Okay. Did she have any outbursts, for instance, towards you or Detective Johnson at any point?
No.
Okay. There was some testimony by Officer Vandenberg that she had made some kind of confusing statements that he didn't really know what she was alluding to back at the scene earlier. Did she do that with you and Detective Johnson?
I wouldn't say outburst with us, no.
Okay. Any statements to you where you just didn't know what she was talking about?
Kind of depends on how you look at that question. It was
Okay.
a lot of statements of asking or telling me how much help she's tried to get for herself.
Okay. All right. Were they responsive to questions you were asking, or did she sometimes just give you information that you weren't necessarily looking for?
There was information I necessarily didn't ask directly,
Okay.
but was given by her.
Was it related to what you were asking?
I would say some of the questions, yes.
Okay. Did you eventually get down to asking her about any knowledge she may have had about the fire at her home?
Yes.
Did she, I guess, what did she say about it initially?
She initially said, I don't have anything to say.
Okay. Did she say, I guess, as opposed to denying that she had anything to do with it? Do you know, does that make sense?
Yeah, that makes sense. She made that statement, and then it was shortly thereafter that is when she disclosed to me how much help she's tried to obtain for not only herself but her children, and that she's contacted the police department to include the jail, and nobody helped her.
Okay. Did you eventually double back to asking again about whether she had anything to do with the fire?
I did.
Okay. Did she eventually make any admissions about it?
Yes.
Did she indicate to you which or who the children were that in total that were in her home prior to the fire?
There's 3 total.
And do you recall their names?
Shemaya, Sharnice, and
I think Officer Vandenberg said Cherish.
Cherish. Yes.
Okay. And Officer Vandenberg indicated Cherish was 10 and Sharnice was 7. Does that I guess, corroborate information that you learned independently?
Yes.
And then Shemaya was 12, as we heard from Lieutenant Elmore. Is that correct?
That is correct.
And do you remember whether you asked those exact questions to the defendant during your interview?
Can't say if I asked direct like age, but I was able to obtain that information prior to the interview occurring because we actually had detectives at the hospital and stuff relaying information, so that's kind of how I corroborated that information.
All right. And did you learn that she was those children's mother?
Yes.
Okay. And that they lived at that home with her?
Yes, she told me it was just those 3 and herself.
As it relates to the fire itself, what did she eventually tell you that happened?
She told me that she did it. There were several statements that she made that I quoted in my report, if you don't mind me referring to it.
Do you have it in front of you?
I do. It's here.
If it'll refresh your memory as to quotes you want to testify about?
When I specifically asked the question, what happened at the residence, she told me she didn't know,
Okay.
but then eventually stated that she burnt her face up. Ultimately, the conversation between all of me, Detective Johnson, and her went on to the fact of how this happened.
Okay. Did you ask her details about how the fire started?
Yes.
And did she give those to you?
Yes.
What did she say happened?
She used lighter fluid and put lighter fluid in the bathroom on the 2nd story, utilized a lighter to light that. She then made her way down the stairs, put lighter fluid all over the couch, and then ignited that.
And did you learn either through other officers or this interview that Shemaya was asleep on that second floor?
Yes,
And was that the bathroom closest to her bedroom that you were aware of or became aware of?
yes,
And then she indicated that she sprayed lighter fluid on the couch on the lower level or downstairs level?
yeah,
Did you take that to mean the main floor of the home?
yes.
Okay. And did she indicate how it was that she started the fire?
With a lighter,
So the fluid along with the lighter itself?
yes.
Did she describe the lighter as, did she say whether it was a cigarette lighter or a grill lighter or anything like that?
I don't recall if it was specifically described to me. She just indicated that she disposed of the lighter fluid next to the couch.
Did you ask or did she volunteer why she did those things?
She didn't volunteer. I asked her. She did make a statement that I did it. I'm not going to sit here and be a victim.
Anything about intentions of self-harm?
Yes.
What did she indicate?
She said she was trying to kill herself and wanted her kids to go with her, so they didn't have to suffer.
Did she give you an explanation as to why it is that she got out of the home but not Shemaya, or I guess, let's just start with not Shemaya.
Yeah, so she indicated that earlier that morning at 5 a.m., the 3 children, were left at the house sleeping, and she went for a walk on Easter and described it as meditation.
Okay. And this would have been prior to the fire starting?
Yes.
And then, I guess in time then, was it your understanding after her walk is when she sprayed the lighter fluid and lit the lighter?
That's correct.
Okay. Again, though, did she offer any explanation as to how or why she got out of the home but not Shemaya?
She said that, I think I understand what you're saying. She had tried to get Shemaya out of the house, but she was unable to go up the stairs because it was too hot.
Okay. I guess, would you describe her statements then as somewhat contradictory? Self-harm and taking her children with her versus getting herself out and...
I'm going to object, Your Honor. I think these have been leading questions, and I think the detective can answer the question.
I'll just leave it at, did you take them to be contradictory or no?
Yes.
At some point, did you learn whether or not Shemaya had passed before or after this interview? Do you know?
I believe before, I believe.
And was it your understanding that the other 2 children thankfully did not have any serious injuries as a result of this?
That's correct.
Okay. At some point, did you learn that Dr. David Stark was the medical examiner who performed the autopsy in this case?
Yes.
And at some point, did you obtain a report back from Dr. Stark containing his findings?
Yes.
Don't have anything else at this point.
Good afternoon.
Good afternoon.
So how long have you been with Major Case specifically?
Over 2 years now, I believe.
Okay. And in those 2 years that you've been with Major Case, I think you said you specifically investigate violent felony cases, infant deaths, is that correct?
Yes, and suspicious deaths.
And suspicious deaths?
Yes.
Okay. Obviously, I'm assuming do you receive special training to be a member of Major Case, or as you are on that team?
I wouldn't say special training. We get sent to training, I guess you would say. I wouldn't say it would be specific to be on Major Case.
And I presume part of that training is in the interrogation process. Is that true?
Yes, ma'am.
How many hours of training do you think you've done regarding, interrogation?
I don't have, most recently in the last 6 months, I did 50 hours of a course, but I can't give a number to it.
All right, so but just within the last 6 months, you've done at least 50 hours?
I believe it's 50, yes.
And part of that training, I assume, involves, how to, communicate with people, obviously.
Yes.
Is there a component ever in any of these interrogation trainings that prepare you to do with when you're talking to somebody that has a pervasive mental illness?
How to like determine that?
How to determine it, and if you are confronted with it, what to do, or if you change tactics when that occurs.
Well, I guess it's a case-by-case basis. If there is any indication of mental health issues or an issue where somebody can no longer participate in the interview, then yes, we would more than likely stop that interview, I guess.
And part of, I guess, the interrogation process obviously is reading somebody their Miranda rights, right?
Yes, ma'am.
I'm confident you've read hundreds, if not thousands, of people their Miranda rights over your career.
Yes.
And you know that waiver has to be voluntary, right?
Yes.
Has to be intelligent, right?
Yes.
And it has to be knowing, right?
That's correct.
And there's several ways for you to advise somebody of their Miranda rights. Obviously, you have to say them out loud, correct?
That's correct.
You sometimes have a card, right?
Yes.
And then you sometimes have them sign that card, right?
Yes.
You do not have a card from Miss Singleton, though, correct?
That's correct.
You read them out loud to her, correct?
Yes.
And then she responded by nodding, right?
Yes.
And then you proceeded to continue to talk to her, right?
That's correct.
And her first thing she said to you was, I don't have anything to talk about, right?
That's correct.
You took that to mean that she wanted to continue talking to you?
She didn't ask for a lawyer.
Okay. So is that a no?
She didn't ask for a lawyer, so I continued to ask questions.
So the only reason you would ever stop asking questions is if somebody asked for an attorney.
That's correct.
And your testimony is that she never asked you for an attorney.
Not that I recall.
You had mentioned, I want to go back a little bit, that you actually appeared on the scene, right?
Yes.
Okay. And she was already in the back of a police car at that time, right?
That's correct.
All right. She was not free to leave at that time, right?
That's correct.
Based on, I think you had said there were some suspicious statements, correct?
Just the origin of the incident, I guess, that was unfolding, yes.
And when you spoke to her, when she was in the police car, you did not read her Miranda rights at that time, right?
That's correct.
But you also didn't question her at that time.
That's correct.
And then she was transported by somebody else to the Grand Rapids Police Department for questioning, correct?
That's correct.
And then that questioning was done by you and Detective Johnson.
Yes.
So to be fair, I think you're the only one who asked the questions, though, right?
I believe so, yes.
So, and again, I think you testified on direct that you weren't really made aware of any of the specifics of the suspicious statements. Is that correct?
That's correct.
But you were in the courtroom today when Officer Vandenberg testified about some of the statements that she said, right?
Yes.
About Shemaya being raped, correct?
That's correct.
She did reiterate that to you when she was being interviewed by you. Is that true?
Yes, ma'am.
In fact, I think it's one of kind of the first things she starts talking to you about, right? And so she talks about how she's been reaching out for help, right?
Yes.
And part of that is that she believed that her daughter was being raped and that no one was doing anything about it, right?
That is correct.
She ends up actually giving you a name of somebody that she believes was doing that. Is that true?
Yes, ma'am.
And I'm asking you this because on direct you testified that she made maybe some confusing statements, but she talked a lot about like being watched by the feds. Is that true?
I don't know if she used the word feds, but watched by somebody, yes.
And she talked to you about how her phone was tapped, right?
That's correct.
She actually talked about how her phone was tapped at least 3 separate times. Do you remember that?
It was about the phone tap. I don't know how many times she said it, but yes.
And so she said at one point that her phone was tapped. She said,
Your Honor, again, I'm going to object as being hearsay. If these are statements by the defendant, Ms. Joyce is not a party opponent. So I don't believe that there's any exception to that rule of them being hearsay at this point.
well, I have 3 responses, Your Honor. First is that they go to her existing mental state, which is relevant, particularly if the court is going to use any of these statements that she made against her. As I already elicited from the officer, that those statements had to be knowing, intelligent, and voluntary. And if there's any indication that they weren't, that's relevant for this court to consider when making a determination whether to accept these statements at all.
I
I do have 2 more. I think that one's probably good enough. But the other 2 I have is that the prosecutor actually brought it up. He's the one who asked the detective about whether or not she made any confusing statements. So I think the door was open, so I think I'll let you explore that. And also the rule of completeness. We're talking about an hour and a half interview. They picked the parts of it that are relevant to their case. However, I think rule of completeness demands, for contextual purpose, that the court is allowed to listen to more of it.
Count, did you want to respond?
Well, just to say, Your Honor, that I don't believe that either of those are exceptions. The rule of completeness does not cover this particular exception. It's hearsay because she is not a party opponent to her client, period. As it relates to then existing...
But the statements, the statements are the defendant's statements that Ms. Joyce is asking about.
Correct, Your Honor. So if I, for instance, if I had not asked Detective Romero about any statements by the defendant, Ms. Joyce certainly couldn't be asking about statements that her client made. That would be hearsay, and I don't think there'd be any question. So I don't see how it's any different because I've asked about certain parts.
I see.
Then existing mental state goes to what someone may plan to do, or I have done, or why I plan to do something. Going on statements about a prior sexual assault that may or may not have happened has absolutely no relevance to the testimony of Detective Romero, and again, it's still not an exception to the hearsay rule.
But it is, and it strikes me that it's really in the form of voir dire for ultimate question about the admissibility of the statements that were given. As Ms. Joyce indicated, if there is an issue with the waiver of Miranda rights, then there may be an issue with the admission of the statements given based on the waiver of those rights. And I think that the defense is entitled to explore that kind of as a preliminary evidentiary matter. And so I would allow it for that purpose, for sure. And I think that's probably sufficient. I don't know that it would have any other direct relevance, but it certainly would have relevance as a preliminary matter for the evidentiary issue. So I'll allow it. I'll overrule the objection.
Thank you.
Thank you, Your Honor. So she mentioned several times about her phone being tapped. Is that correct?
Yes, ma'am.
So at one point, I think she uses the actual phrase, she says, "My phone tapped up stupid." Do you remember her saying that specifically?
Not specifically, no.
Okay, but let's see. She also talked about her life being turned around because of her tapped phone, correct?
I believe so, yes.
She talked about being watched by her neighbors, correct? A lady and daughter watching her, is that correct?
Yes.
She talked about a party she had in April of last year, right, that she said was a Fed party. Do you remember that? Or Easter party?
I remember her talking about a party. I can't say whether she indicated a Fed party or not.
And actually, at some point talking to her, you discovered that she was hospitalized at Pine Rest, correct?
I believe so, yes.
She volunteers that to you, right?
Yes.
And I guess I have a question about timing. I know this was kind of a dynamic situation, right? And you actually talked to her pretty early on, right?
Yes.
And at any point were you made aware of the fact that she, aside from what Ms. Singleton told you herself, that she had been hospitalized at Pine Rest?
I don't believe so.
You personally never made aware of it. Is it possible that other members of the team investigating this case were made aware of it?
It's very possible, but not directly to me.
And I guess, let me ask you this. If you find out that somebody has been hospitalized at Pine Rest for some sort of serious mental illness, would that change your way of how you would interrogate somebody?
No.
So if you believe that they were actively in a state of being mentally ill and actively delusional, that doesn't change your opinion on how you should interrogate them?
If they were showing signs actively, yes, it would change, but she was not showing those signs.
So her talking about her phone being tapped, right?
Yeah.
Her talking about being watched by her neighbors, right? Her talking about her daughter being raped. All of these things, you don't think any of these things were signs that she was mentally ill at all?
I can't say specifically. I'm not a doctor to diagnose that, but I've had several people make similar statements throughout interviews.
And when she tells you that she's been involuntarily hospitalized, still you don't think, well, maybe some of those statements were kind of weird?
I mean, they're kind of weird, but it doesn't stop my investigation because she's acting and answering my questions that I'm specifically asking her.
Even though the predicate for all these statements coming in is that they are knowing, voluntary, and intelligent, right? That her waiver of Miranda was knowing, voluntary, and intelligent.
That's correct, because she responded that she understood them.
And when you say she responded, she understood that. She literally nodded once at you.
That's correct.
And I guess to continue, in regards to some of the things Mr. Early elicited, she talked about wanting to die herself, right?
Yes.
And she told you, you know, she was at the end, kind of of the interview, she told that she was finally, you know, she was just finally able to tell her story, right? She felt free, right?
Yes.
A story that included being surveilled constantly, right?
Correct.
And also part of your interview with her is you found out she had a 10th grade education, is that correct?
Yes, ma'am.
You talked about the medication she's on, right?
I believe so, yes.
She indicates, I think she calls it Whisperidol, I think it's Risperidol, but she talks about the medication she's on, correct?
Yes.
Which is antipsychotic.
I don't know what, I'm not.
She talks about that she had a prescription for that when she left Pine Rest, true,
I believe so.
but that she ran out, right?
I believe so.
And she hadn't been medicated for at least a month, correct?
I don't know specific time, but I do believe she said that she was not medicated.
I don't think further on.
Right, anything further from the people?
No, thank you.
All right, you may step down.
People have no additional witnesses to their
Okay. Do we need, are there any other?
I'm sorry. No additional witnesses for at this stage. Thank you.
Okay, all right. Did the defense have any witnesses?
No, Your Honor, thank you.
Okay, then we'll hear argument from the people.
Thank you, Your Honor. As it relates to count one, felony murder, that's dictated, the elements are dictated by criminal jury instruction 16.4. That what happened here, Your Honor, well, during the perpetration of committing an arson, she did murder one Shemaiah Stewart, which was her 12-year-old daughter. Obviously, one of these states of mind has to be intent to kill or creating a high likelihood of death or great bodily harm. I believe with her admissions to Detective Romero, that intent is clearly established. As it relates to count two, first-degree arson, it's dictated by jury instruction 31.3. There is clearly images, evidence in exhibits 1, 2, and 3 that show the damage to the home that the defendant and her children were living in at 956 Eastern. She clearly did destroy or damage most of this home, which obviously was a structure and real property. Its contents, and it resulted in physical injury to Shemaiah Stewart. Again, death is physical injury, so I believe there is probable cause for that charge. As it relates to child abuse, second degree, there are 3 counts, 3, 4, and 5 related to Shemaiah, Cherish, and Sharnice. All 3 of these young ladies were children. They were in the care of their mother, living with their mother, and at the time they were living with her mother, the defendant, knowingly or intentionally, commit an act likely to cause serious physical harm or mental harm, for that matter, to a child by setting their home on fire. The fact that 2 of the children thankfully got out relatively unscathed physically should not work in the defendant's favor. We believe that based on the testimony of all three of these witnesses this afternoon, Your Honor. We have shown probable cause for each of these counts and asked respectfully for bond over. Thank you.
All right. And defense.
Thank you, Your Honor. We would oppose bind over on all 5 counts. I think based on the testimony this court has heard today, it has to believe fully the alleged admissions that my client made in order to make any kind of probable cause determination that this fire happened at her hand. Because without those admissions, all you have is that there was a fire and that there was injury and that somebody died, but you have no indication of what happened. So if these admissions do not exist, as I believe they should not be considered by the court, then I think the court would have to dismiss this case today. The reason why these statements should be not admitted by the court or not accepted by the court is for what I talked to the court about during my response to Mr. Early's objection. This court has the authority to consider the admissibility of all evidence, and if it finds that evidence was gotten contrary to constitutional law, the court is allowed to suppress or not admit it at all. And I'm asking for the court to suppress her statements because this waiver of Miranda was not knowing, voluntary, or intelligent. It is clear from the testimony elicited by the first witness that on the scene that she was, quote, ranting, talking about Shemaiah being raped.
Let me pause you for a second because I want to make sure that I understand what standard would apply. Certainly we could evaluate that in hindsight based on all the information that is provided on the record. I mean, that's one way to evaluate it. Another way to evaluate it would be to apply a subjective standard to the interrogating officer and put ourselves in the shoes of that interrogating officer. What did that officer know? And I guess it would be an objective standard. Would a reasonable person in that position find that the statement was knowing, voluntarily, and would otherwise legally suffice as a valid waiver of the Miranda rule? And then I'm assuming that there is some level of good faith, even if the court now sitting in hindsight looks and says it probably wasn't. As long as there was good faith on the part of the interrogating officer, then wouldn't that be constitutionally viable? I mean, that's what I mean. What I need to understand is the standard that is supposed to be applied here.
So is the court asking me whether it's a subjective standard, an objective standard, or good faith, or all three?
Yeah, exactly.
Okay, thank you, Your Honor. I guess my answer is I don't know that good faith applies to Miranda violations. That's something I do not know the answer to for this court. As far as whether it should be a subjective or objective standard, I think that, first of all, we win under both, frankly. But if it's an objective standard, then it would be whether or not a reasonable officer believed that it was a knowing and intelligent and voluntary waiver. And I can continue to make argument, or based on the testimony we heard from Detective Romero, I believe that a reasonable officer would take pause because there was clear delusions that were being expressed to him that were just being brushed aside. They weren't mentioned even in his initial direct testimony. I don't know if it's because perhaps I think they didn't matter or because it was irrelevant, so to speak, but the fact that somebody's telling you, I'm experiencing these extreme delusions, oh, by the way, I was involuntarily hospitalized, oh, by the way, I was on medication, oh, by the way, I'm not on that medication anymore. All of those things are objective indicators that perhaps this isn't reliable admissions, and therefore shouldn't be considered by the court. So I think under an objective standard, we're successful. And I think under a subjective standard, for those same reasons, we're successful as well. I don't know if good faith applies as far as Miranda violations. That's something I would have to brief this court on. I don't know for sure the answer to that question. But I think everything that we just argued indicates that these are statements that should not be admitted to a court as even probable cause proof that she was the cause of this.
Right. Well, and the court understands that it does have it does have to make a determination as to the admissibility of the evidence, and if there was a Miranda violation, then it is within this court's authority to and duty to analyze that question and make a ruling on it. That's expressed in the court rule. What authority should the court look at? Is there? I mean, certainly I'm familiar with the general requirement that a waiver be knowing, intentional, etc. But as far as how we evaluate that, is there a particular case that you would point the court to?
Not at this time, Your Honor. Again, I'd have to have time to brief that for the court. I would say this, I believe it falls particularly under the intelligence arm of the question, and I know that mental health is a consideration for that. I do not have a specific slide for the case or the court at this time.
Okay. Anything else?
No, Your Honor.
Okay. Let me check in with the people. I just want to give you a chance to address those questions as far as the admissibility and the waiver, particularly the waiver of...
Certainly, Your Honor, and I know there is several different cases related to this particular issue. I don't have a name of one off the top of my head, frankly. I didn't think this motion was going to be made at this time. I believe that based on Detective Romero's testimony, the willfulness of her waiver and the information, the relevant information that the defendant admits to is rational. For instance, we have a house engulfed in flames. We have a child who is brought out of that home that is the defendant's child. And then we have admissions that she lit the house on fire. Not that some strange being or one of these folks that tapped her phone did it. You know what I mean? There is a connection between the evidence physically and what she tells the detective. There isn't some, I guess, kind of out of the ordinary story that we're just trying to piece together to connect it to the defendant in this case. The defendant said, I did these things. I used lighter fluid, I used a lighter. This is where I sprayed the accelerant. She was burned. There's evidence that she was in the home as well. She indicated that she may have went either back inside or stayed inside after having a change of heart on committing suicide. That's a rational thought. And so as the detectives are listening to that, it makes sense that she would act this way after having these thoughts. Whether she's talking about some other incident that didn't exist or they don't know whether they exist or not, they would have to fact check every suspect's statement every time they made a statement of, well, I didn't do it. Even if the even if the detectives have, video and overwhelming evidence that they know that a defendant is lying, that doesn't make them an incompetent person to give a statement. Even when they have absolute proof that that person is not telling the truth. Here, detectives had information where the defendant is corroborating, as I said, that information, that 3 children were in the home, their names. I believe at some point she even indicates, and I realize we didn't make a full record of every word that the defendant said, but there was a lot of obviously corroborating evidence that the detectives took. So to say, because she's talking about a sexual assault that may or may not have happened of her daughter, that doesn't make her incompetent to know whether she waived her Miranda rights or not. Case law is clear that it has to be unequivocal, an unequivocal request for an attorney or an unequivocal stopping of questioning, and there was no record made by Ms. Joyce of that in this case as far as any unconstitutional waiver. At this time, I guess I don't have any additional argument.
Let's take a little recess. I'm going to take a look at some things and we'll reconvene. Thank you.
When we go into the
court has had some time to review both the factual record and the law with some detail. And I am prepared to rule on this matter. The question is before the court, of course, on a preliminary examination, which requires the circuit court to determine whether a felony was committed, whether there's probable cause to believe the defendant committed it. Probable cause exists where the evidence is sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. In order to establish that a crime has been committed, the prosecution need not prove each element beyond a reasonable doubt, but must present some evidence of each element. Additionally, if the evidence conflicts or raises reasonable doubt concerning the defendant's guilt, the defendant should nevertheless be bound over for trial, at which the trier of fact can resolve the questions. The defendant is charged with felony murder here, but the underlying principal offense is arson. For there to have been arson, the people would have to prove that the defendant burned, damaged, or destroyed by fire or explosive or any of its contents. If any part that is of the property, if any part of the contents is burned, no matter how small, that is all that is necessary to count as burning. The property does not have to be completely destroyed. Second, it must be shown that the property was burned, damaged, or destroyed, that the structure that was destroyed was in fact a building, structure, or other real property, or any of its contents. Third, that when the defendant burned, damaged, or destroyed the property or any of its contents, she intended to burn, damage, or destroy the property or its contents, or intentionally committed an act that created a very high risk of burning the property or its contents. And while committing the act, the defendant knew of that risk and disregarded it. Fourth, that as a result of the fire or explosion, an individual was physically injured. And I'll go forward with the elements of the remaining counts as well. With regard to felony murder, it must be shown that the defendant caused the death of another individual and that the individual died as a result of the alleged act. Second, that the defendant had either the state of mind to intend to kill or intend to do great bodily harm, or knowingly created a very high risk of death or great bodily harm, knowing the death or such would likely occur. Third, that when the act that caused the death was committed, that the act that caused the death was a felony. Finally, with regard to second-degree child abuse, it must be shown that the defendant was the parent or guardian of a child, and that the defendant had the care, custody, or authority over the individual, that the defendant knowingly or intentionally did an act likely to cause serious physical or mental harm to the child, regardless of whether such harm resulted. The facts of the case as were borne out here at this preliminary examination are that the defendant admitted that she intentionally lit the house on fire. She, as was stated about the admission that she made, she used lighter fluid in the upstairs of the house, poured that lighter fluid around the bathroom, used a lighter to light the lighter fluid on fire, then went downstairs and poured additional lighter fluid in the downstairs area and then lit that as well. She also testified that, or she admitted to police while in custody that she knew, and circumstantial evidence would otherwise suggest that she knew or should have known, that the victim in this case was, in fact, sleeping upstairs where she first lit that fire. Based on that, the court would find that all of the elements for the first-degree arson charge were met. The court would also find that as a result of the commission of that felony, that the victim here died, and the evidence suggests that the cause of that death is, in fact, a result of the fire that was set intentionally, otherwise the felonious act of the defendant. Likewise, the court would also find each count of second-degree child abuse based on the same conduct that would otherwise constitute conduct that would be likely to cause serious physical or mental harm. I think the testimony, the court can, at least by probable cause standard, could find that that physical or mental harm actually did occur. Certainly with regard to the deceased, the court would find that and could find that. Probably could find it with regard to the other two children, but if not, the court would find that intentionally lighting the house on fire with the individuals, with the children sleeping inside, is an act that would likely cause serious physical or mental harm. So the court would find a probable cause for the 3 counts of second-degree child abuse. Now, the court's finding of probable cause here does rely on the admissions that were made by the defendant while she was in custody. And at least as far as the record that exists before the court today, without those admissions, there may not be enough evidence for probable cause here. Which begs the question then of whether those admissions legally can be considered by this court. The defendant has raised the issue indicating that the admissions, that the statements, custodial statements made by the defendant are constitutionally invalid and should be suppressed under the exclusionary rule. Procedurally, this court does have to address that question. Under MCR 6.110, which is the rule that governs preliminary examinations in the district court, if the court determines that evidence being offered is excludable, it must, on motion or objection, exclude the evidence. And it is, the rule is very clear that the court must, in fact, exclude the evidence if the court finds it excludable. Now, the rule does go on to provide that the district court's finding or determination on that issue is not a final one. Whether or not it was raised here, it can be raised fresh and reviewed de novo by the trial court. But nonetheless, under the procedural rule, the court does have an obligation to answer that question. Turning then to the merits of the argument that the admissions are constitutionally infirm and should be excluded under the exclusionary rule, we start, of course, with the Fifth Amendment to the United States Constitution that prohibits a person from being compelled to be a witness against himself or herself. In Miranda versus Arizona, the United States Supreme Court concluded that statements made during a custodial interrogation would violate the Fifth Amendment unless the defendant voluntarily, knowingly, and intentionally waived any right to self-incrimination. Of course, that famously led to the rules that we're all familiar with now, that police must read an individual their Miranda rights before conducting custodial interrogation, in which they must advise the defendant of the right to remain silent, the right to an attorney, and how the law would work on that point. That, in practice, has led to almost a scripted statement that police often use and often is read from cards or forms to ensure that that defendants are properly advised of all of their rights and there's no issue with the advising of those rights. Now, when there is an issue, before there's an issue, the people's obligation is to show by a preponderance of the evidence that the statements or admissions, the custodial admissions, were made knowingly, voluntarily, and intelligently. It is a simple simple preponderance of the evidence standard, with the people carrying that burden to show that they were in fact made knowingly, voluntarily, or intentionally. There were two components, I think, to the challenge. First was the question of whether indeed the defendant expressed affirmatively the desire to waive Miranda rights and the right to remain silent. Importantly, and specifically, defendant pointed to the suggestion that the expression was mere shaking of the head, not a verbal statement of the desire to waive the rights. As far as the court can tell, there are no magic words. I don't believe there's anything signed here. At least the testimony was that there was nothing particularly signed. The form is not important. What is important is whether the evidence would suggest a willingness to waive the rights and to continue and provide statements. And I think that is fleshed out rather well in a case called People v. Matthews, 22 Mishap 619. It's a 1970 case from the Michigan Court of Appeals. The court would find that there was at least an expression, there was an affirmative expression by the nodding of the head, but that in addition to that, there is the action of the defendant to continue to answer the questions and continue to speak, which is a little bit different than the waiver required or the waiver at issue with regard to the right to counsel. But here the court is satisfied that there was an express waiver of the rights. Now the question becomes whether that waiver was knowingly made, voluntarily made, and intentionally made. The primary problem is with the knowing and intentional components of any waiver. Here, what is being alleged is that the defendant had diminished ability to understand potentially reality, was suggesting or was showing or manifesting thoughts that from an objective standpoint might seem delusional, including fear of wiretapping and conspiracy, and thoughts that individuals were watching her and that there was a conspiracy to harm her. The standard that the court is to apply is to take into account a totality of the circumstances. And I'm looking at a Michigan Court of Appeals published opinion from 2006. The people of the state of Michigan versus Mary McBride, which is Michigan Court of Appeals docket number 271579. And in that opinion, it indicates that whether a suspect has knowingly intentionally waived his Miranda rights depends in each case on the totality of the circumstances, including the defendant's intelligence and capacity to understand the warnings given. This can only be done by examining the objective circumstances surrounding the waiver. To waive rights intelligently and knowingly, one must at least understand basically what those rights encompass and minimally what their waiver will entail. Although to knowingly waive Miranda rights, a suspect need not understand the ramifications and consequences of choosing to waive or exercise the rights. The state must present evidence sufficient to demonstrate that the defendant understood that he or she did not have to speak and that he or she had the right to the presence of counsel during the questioning. Taking all of the circumstances here into account, the court would find that the people did provide and did establish that that minimum showing. While there is certainly demonstration that the defendant's thoughts may not have been completely and objectively without cause to question whether there was some level of delusion. What we do have, even though there may have been delusional thinking, the defendant appeared to understand basic concepts. There was no indication that there was any struggle with understanding the nature of where she was, the fact that she was being questioned by police. She explained what happened in the house, and while there are little spurts of what seems to be delusional thinking, there are also long areas where she's able to recall and articulate facts. Based on all of that, the court would find, under the appropriate standard, that that the waiver of the Miranda rights and the defendant's decision to make statements, incriminating statements, to law enforcement while in police custody was knowingly, intelligently, and voluntarily made. And the court will add that most of the case law, and certainly how the case law developed with regard to this, is focused on precluding tactics by law enforcement, and is primarily concerned with the voluntariness of admissions. There's nothing to suggest that there was anything done here to coerce the admissions. I think there is at the very least a level of understanding and cognition that's demonstrated by the defendant, show that she understood that she did have the right not to speak and did decide to do so nonetheless. So based on that, the court would deny the defendant's request to exclude the admission evidence, and based on the foregoing, then the court would find probable cause to bind the defendant over to trial on the charges in the complaint. Counsel, have you talked to your client about a circuit court arraignment and waiver of that?
Yes, and I can approach her and we did execute that.
Okay. Is there anything else we need to address?
No, people.
No, Your Honor.
All right. Thank you, everyone. Good luck with everything.
Thank you, Your Honor.